Is there ever an instance in your medical malpractice case, in your accident case, in your wrongful death case, where the defense during settlement negotiations will pay you more over and above what you are asking for to settle your case? Would you like to know the answer? Come join me for a walk around the lake as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The short answer is no, that will never, ever happen. Now, you might be thinking, okay, wait a second. Maybe, like with a house, I can get them into a bidding war, and now they're going to increase the price in order to get what they want. Or maybe you go to buy a brand new car that has a huge demand, and now you're hoping that they will pay over invoice, meaning more than what you are asking for. The answer is absolutely not. The defense has no reason and no incentive to pay you more than what you are asking for. So now, does that mean that when you start settlement discussions, your attorney should be asking for double, triple, quadruple what it is that you are asking for? The answer is maybe yes, and then again, maybe no. Whatever amount of money we request at the very beginning, the defense knows that that is often not the final number that you will accept in order to settle the case. They recognize that you are there to try and negotiate. Now, it is different in a scenario where we come right out and say, listen, my client's injuries are worth $10 million. He was the CEO of a company earning $5 million a year. He won't be able to work over the next 30 years. And now we have actual hard numbers to back up the fact that he is losing all this income together with his pain and suffering. So we could, in certain instances, come right out and say, okay, our demand in this case is $10 million. If you are interested in settling this case, that is the number. We think that if we go to trial, a jury will come back with double, triple, quadruple, 6, 7, 8 times that amount. Now, that may be a possibility. However, in most cases, the amount of money that we initially demand, the defense knows, if they've been doing this for any period of time, that the initial settlement demand is not the final number that we are willing to accept. Now, when the defense makes an initial offer, we know from the plaintiff's standpoint that that is often not the only offer they are going to make. Unless, of course, they come right out and say, listen, we're going to offer you $25,000 against your demand of, let's say, $5 million. In that instance, we know that they are not serious in trying to settle your case. So, at that point, we say, thank you very much. You're not even in the same universe as we are. Let's just go ahead and get a trial date and we'll proceed to trial. Is there ever an instance where the defense will turn around and offer you more than what you are demanding? In my opinion, the answer is absolutely not. They have no interest, no incentive, no desire to do so. When you make a settlement demand, when your attorney makes that settlement demand, he is telling them the top number, the maximum, that he is willing to accept in order to settle your case. So, your attorney knows that that's not the final number. The defense attorney knows that that's not the final number. The key question is, how close can your attorney get to his real number? How close can the defense get to your real number in order to properly compensate you for all the harms and losses and damages you incurred? Will they ever pay you more than what they feel the injuries are worth? The answer is no. In that instance, if you are still not satisfied with whatever offer they have made, now you have no choice but to go to trial. And then you are relying on 6 members of the community, people whom you do not know, people who know nothing about your case. They know nothing about the facts of your case. They know nothing about the injuries or how it has affected you on a daily basis. They have no idea what's going to happen to you in the future or how your injuries are going to affect you and your family into the future. They don't know whether or not you've lost income. They know none of this yet. It is going to be your attorney's job to teach and educate this jury about every one of those aspects. Only by the end of the trial, after having educated them with all the testimony and all the evidence and showing the jury how significant your injuries really are and how it has affected you on a daily basis, the goal here is to try and maximize the value of your injury so that the jury recognizes that you have very substantial injuries that will affect you for the rest of your life. In that instance, we hope and expect that the jury is going to give you a substantial amount of money as compensation for all of the injuries you suffered. But what most people don't talk about is that there's an inherent risk associated with that. Now, what's the risk? It's a risk of going to trial. It's a risk of the unknown. It's a risk of having 6 members of the community relying on them, thinking that they are going to give you at least what you ask for, if not more. And that's the hope and the expectation that you and your attorney have. However, along with that expectation, there should also be the knowledge that there is the possibility that the jury could totally disagree with you and your experts and throw your case out without you getting a single dime. That is a possibility. The jury could also come back and agree partially with you and your attorney and say, you know what? We agree that something was done wrong. We agree that that wrongdoing caused you harm, but we do not agree with the amount that your attorney thinks you should receive as compensation. And now they give you a substantially lower amount than anything you were offered as settlement before, which, by the way, the jury is never told about, and they don't know about any settlement discussions before the trial. And when that happens, you have very limited choices, very limited options at that point. You and your attorney will have to decide whether or not you will or could appeal the case, assuming there are errors of law. And even if you could, you don't know what an outcome, you don't know what the trial judge will do, and now you don't know what an appellate court is going to do. Now, let's turn this around a bit. Let's say, for example, you go to trial, and a jury comes back and awards you much, much more than you ever could have imagined, much more than your attorney has requested. Now, the first thing that's going to happen is the defense is going to ask the judge to throw your case out, claiming that the evidence does not support this verdict. The judge can either leave the verdict alone, he can reduce the verdict, he can, in some instances, increase the verdict. He can turn around and say, you know what? There were problems here. I want you to start the trial all over again. Regardless of whatever decision the trial judge makes in what's called a post-trial motion, the defense, in all likelihood, is going to appeal that. And now when the case goes up on appeal, the appellate court has many options as well. They could leave the verdict as it is. They could reduce the verdict. They could increase the verdict. They could throw it out totally. Or they could say that there were errors of law made during the course of trial, and now we don't know exactly what the outcome would have been, so we're going to send this back, and now you guys are going to try this case all over again. Or maybe they say, listen, there were errors made just calculating the damages here, so we're going to send this back for a trial to determine how much money the jury is to give you. So let's get back to the question I raised at the beginning of this video. Is there ever an instance where the defense will turn around and give you more money than what you initially asked for at the very beginning during settlement negotiations? The answer is absolutely not. There's no reason to, there's no incentive to, there's no bidding war that they're going to get into, because there's no upside for them to offer more money. Their goal is to try and limit and minimize the amount of money that they ultimately have to pay out, assuming they are responsible for causing your injuries. So why do I share this quick information? I share it with you just to open your eyes, to help you understand how these types of cases work in the state of New York. You know, I recognize you're watching this video because you want to see the beautiful scenery. No, I recognize you're watching this because you likely have questions or concerns about your own matter. Well, if your matter did happen in New York, and you are thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207, or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.